Thanks everybody and welcome back. For those of you that are looking at your screen carefully, you'll see that Ms. Te Aho is not with us. We're not quite sure what's happened. We've called her and messaged her and haven't got a reply. So we're assuming that there's some personal circumstances arisen urgently that she's needing to attend to. What we're proposing to do, and I just want to make sure that no one's got any problems with that, we'll just proceed as planned. The proceedings are being recorded. Ms. Te Aho will catch up. She won't get the opportunity to ask any questions this afternoon, but she will be available to hear that recording in due course and then help us with our deliberations and contribute fully with them, to them. No one has any objection to that, I'm assuming? That's good. There being none, we'll kick off. Mr. Mackey, we wanted to give you the opportunity to, I guess, to do two things. One, there were a couple of questions that we left you with. If you could report back on those, together with any matters that that you'd like to address us on that have arisen during the course of the hearing. I don't think we need to hear from you in terms of saying, I've heard from party X and I haven't changed my opinion. It's really those matters where you think some further comment from you would be helpful to us, or where you might have thought about something and changed your view on something. So we're in your hands, Mr. Mackey. So off you go. Thank you.
Thank you. I have prepared something brief in writing, and I'll read that through and provide it to you in written form.
Thank you.
It does include some of the cases where I've not changed my recommendation, but I won't speak to those as I go through it.
That'd be great. Thank you.
The first question was Mr. Dromgold, who sought to install a domestic wastewater treatment system at a quarter-acre site in Tuakau. That's actually a permitted activity within the Waikato District Plan, as long as it meets the Australian-New Zealand standard. However, it would have to meet the regional plan requirements, as it's a discharge to land and possibly to groundwater. And I'm not sure that the system he's proposing would be able to achieve the standards required within the quarter-acre area. So the short answer to him is what he's proposing is a permitted activity within the district plan. He has to work it out with the regional plan.
Thank you.
The second one was about the indicative road off Redwood Grove, Mr. Greeny. Council roading engineers are seeking a solution to property access to allow future subdivisions. And one option, the main one, is Elmwood Lane becoming a public road. It hasn't yet been achieved. I understand the legal position is to be, as described to you yesterday, that it's currently a group of private rights of way, which would have to be either surrendered or vested or acquired by the council to form a road. I can only suggest that more time is allowed for that resolution to occur before a decision is made. It may not be possible to put in a provision to the plan saying that the indicative road will only stay off Redwood Grove until Elmwood Lane is completed, because that may not be the solution that's eventually reached. And the indicative road does form a backup solution to prevent some of that future subdivision potential being landlocked. The next one, McCracken Surveys Limited, Mr. Barrett, and the surveying company, Mr. Shaw, in relation to the Regional Infrastructure Technical Specification, the RITS. It's a code of practice outside the plan, and it's really a set of deemed to comply solutions. So if you make your public infrastructure proposal in those forms, then they're considered to meet the council's requirements. If the district plan is going to refer to a document outside the plan, then it needs to refer to a specific edition and date of that document, and any changes later on would require a plan change to the district plan to refer to a new document, so it ceases really to become a live document.
Yeah, thank you.
in relation to the narrower vehicle access widths that were proposed for the, I think, 2 to 8 sections, I don't support the changes, and alternatives are available by restricted discretionary activity resource consent. So if you have an infill proposal where you've got an existing house blocking access, you can get a resource consent for a narrower access past that existing house, but it just needs to be managed through the resource consent process rather than made a permitted activity. First gas seeks a definition of gas transmission network to include the above ground gas stations and mapping of the gas stations. I don't consider that the definition is required, as the gas transmission network is on the planning maps. The gas distribution network is not. And all of the gas stations are located within that linear network. So while they're not marked separately, they are all within that line of the network. If there were an additional suite of rules for the gas transmission network and the gas stations, then there would be a need for that more definitive mapping and definition. Water care seeks an additional policy to enable infrastructure within identified areas. Apart from that being a relatively broad relief that they're seeking, there is a policy 6.1.2, development, operation and maintenance of infrastructure, which already provides for functional and operational need and for location, route and design needs. That policy would be the one that would support regionally significant infrastructure locating within the identified areas where there's an operational, functional, locational or route need. I think that's precisely what the argument was being made by Watercare. If you were minded to include more policy direction, then that allowance for functional operational need could be enlarged to say even within identified areas, but I'm not sure that you'd propose to go that further.
You're saying keep it non-compliant and have the policies there.
I think the policies need to be weighed, otherwise you will be overriding any protection for the identified areas that should be put into the balance. Next one, Genesis Energy seeks changes to an objective and policies, but I don't agree those changes are necessary. Well Networks raised 4 outstanding issues for further change. Wanting a service berm rule. There's already a minimum services requirement within the table in the berms column, which is 1.2 metres wide for the narrower roads and subject to specific design that has been certified by the council for the wider roads. So that is effectively already in there. Minor upgrading of existing infrastructure, they sought to include a 10-metre relocation of poles as a permitted activity. I consider that to be mounting to a new location rather than a minor upgrading. I note the Auckland Unitary Plan with which I've worked allows for a 2-metre relocation and up to 5 metres for road safety purposes. That's to deal with the car meets pole problem that occurred. The permitted activity, small and community scale renewable electricity generation and roads. I consider these and their ancillary equipment may have effects which are not covered by the permitted activity standards or the corridor access request process. And that is the larger effects of the larger windmill type things and possibly the electricity storage cabinets that they're going to use if they need a large amount of battery array to store the energy that's produced. On whether more than 20 kilowatts capacity could be allowed as a permitted activity, the 20 kilowatts is just to ensure that the permitted activity is a known net effects scale of operation. Larger generation could have effects assessed as a restricted discretionary activity. And the example given of a large rooftop array of solar panels within a commercial area, I see that would be consentable since it would have minimal effects, but a more than 20 kilowatt windmill on the top of a commercial building could be a very large structure and could have significant effects. In relation to the Department of Conservation, they've agreed to recommended changes on the basis that the significant natural area mapping does not include bat habitat necessarily. So they have agreed, but I note that the hearing that dealt with significant natural areas had a recommendation that there not be mapping of those areas, and that a significant natural area would apply to any area that met the criteria. So that maybe moves things into a bit more uncertainty in the future. The NZTA Wakakotahi seek changes to the trip generation rates to align with the New Zealand 85th percentile report that they have prepared, and to use the terms equivalent car units and equivalent car movements, with a truck being equivalent to 3 car units. I think this equivalence might be useful and suitable for modelling traffic movements, which was its original intention, but in my opinion it does not allow for other transportation aspects such as intersection design and management, weight loading on roads, and the configuration of roads and vehicle accesses required by trucks, all of which are different to cars and not equivalent to 3 cars. I think Ports of Auckland also, Mr. Arbuthnot, identified that some activities would require a high proportion of heavy commercial vehicle movements, so they should not be just equated to more cars or less trucks. Counties Power Limited did not persuade me to change my recommendations, but they did start to provide information that faults in underground lines are harder to find. However, they didn't produce very much evidence on the causes of faults, including wind, storms, vehicles hitting poles, trees and branches falling on lines, and mobile equipment hitting lines like forklifts and cranes. I think that should have been provided if they were to persuade us that lines overhead are more resilient to faults than lines underground. The larger switch rooms that they showed us and told us about demonstrated no management of their adverse effects, and the submitter also stated that they are established within designations by an outline plan of work, so it would seem not relevant whether they were a permitted activity or required restricted discretionary resource consent. They would be managed by an outline plan of works. Spark, Vodafone and Chorus seek more straightforward consenting paths within identified areas. It was unfortunate we had no evidence from Heritage New Zealand, Pohuri Tonga, which sought the heritage protections. In terms of service connections to heritage buildings, it should be noted that a rural broadband service connection would be a 1.2 metre diameter satellite dish. That's not just a simple wire going to an insulator on the face of the building. In practice, the service connection restricted discretionary activity will manage the type and location of service connections, and whether they are trenched or thrust underground or allowed overhead. A controlled activity would be unlikely to achieve that. Transpower reiterated its submission and evidence which I'd covered in my rebuttal evidence. The only change in my recommendations is that non-complying activity NC9 should be amended from PSA disease control structures to protective canopies. I think that's with the agreement of Transpower and Horticulture New Zealand. Finally, Kainga Ora on the National Grid subdivision corridor. Whether we pursue that further, subdivision is generally restricted discretionary activity, and the nuances of a cigar-shaped area of effects, actual effects, can be dealt with within the subdivision consenting process. So it doesn't require accurate mapping, which was carried out for the Auckland unitary plan, and particularly not within the rural area. The outstanding issue, I think, is the vibration and noise or noise-sensitive activities along the transport corridors. On vibration, we appear not to have sufficient evidence to reach a final conclusion on vibration effects management, and it may be safer to make it a subdivision matter of discretion rather than a separate rule. On noise, I think the problem has been demonstrated, both reverse sensitivity and health and safety, but there may need to be variation between rural and urban residential areas, and the village and country living zones also blur that issue further. And there may also need to be some allowance for a lesser buffer where the state highways are of a slower speed or lower traffic volume or have less heavy vehicles. And that was the State Highway 23 at Raglan that Mr. Stiles demonstrated in his evidence. So I think there may be further work on that, but a problem has been demonstrated, I think, and the principal evidence on that was from the World Health Organization that's been adopted by NZTA and
So we would have to have another hearing. We'd have to go away, or someone would have to go away, get that information, and then we'd have to have another hearing, wouldn't we?
the information you're talking about is the relative busyness of the roads and whether they might need a different buffer. I don't think you've had the information provided to you by Mr. Stiles to do that, and NZTA have not accepted that that's a valid distinction to be made. However, I don't think we could confirm the rules as currently proposed without having that information available to us.
So, sorry, I might be misinterpreting. Are you saying that you're supporting your original, you're still supporting your original recommendation on noise sensitive issues?
I'm supporting it as it stands now within my rebuttal evidence, but I'm aware that it would almost certainly be appealed, and there needs to be some way to refine that further. I think to get to an end state, it would be a safe decision.
Well, you know, if we go off and get new information as to different road surfaces, and that information must be put to the other parties, and they must be given the opportunity to comment. So we're looking at another hearing probably.
The other alternatives, I guess, are you either grant the relief in some form and it becomes the decision that is challenged rather than the evidence, or you reject the resolution and we fall back to the notified provisions, which then may call an appeal from NZTA about needing something stronger within the plan.
Well, it's not our job to worry about appeals, I can tell you that. We make the best decision we can.
Yes, I agree that that is just the likely outcome of making a decision which goes either way, that it will be the appeal process which will have to resolve the issue.
Okay.
That's the end of my reply.
Thank you, Mr. Mackey. Let's just see if there's any questions that arise. The good news is that there's been a fire alarm at the Auckland University where Ms. Tiaho is, and apparently it's not a drill. They're actually not allowed back in the building. So when I say that's the good news, the good news is that she's not incapacitated or injured or got a crisis on her hands. So just give you an update on that, but let's see if there's any questions for you. Mr. Fulton, any questions?
Yeah, no, I don't have any further questions. Thank you.
Ms. Gibb?
No, thank you, Mr. Mackey.
Mr. Cooney?
No, thank you.
No, and I don't have any either, but you've got that information in writing, as I understand it, Mr. Mackey, and you'll be able to get that provided to us in due course. And
Yes,
Mr. Bell, if he could post that on the website so that that's visible to everybody, that would be helpful.
very good.
All right. I think that brings us to the end of this particular hearing. What we're going to do is to adjourn the proceedings at this point, as is normal practice. The panel will deliberate in terms of considering further what it's heard. To the extent that we feel that we need to issue any further directions regarding the sorts of matters that we've raised earlier in the hearing, e.g. further liaison between parties on certain provisions, or some areas that would be improved by recrafting, etc., we'll do that in due course. We're not going to get into any of that today. Are there any matters that anybody, before we formally adjourn, that anybody wishes to raise? There's nothing from the panel. So I think that just suffices for me to say on behalf of the panel, thank you for all those that have contributed to the hearing and the manner in which you've presented the information to us. It's been a big topic. We've received a lot of information, and the amount of agreement is pleasing. Nevertheless, there's a few fairly knotty issues that we've still got to consider and get our heads around. But we're up for that task, and we'll do justice to it, hopefully. So on that basis, thank you, everybody, and we're now adjourned. If the panel could just stay on the line.